Hello everyone, this is Sachin Sawant, your UK immigration lawyer. In today's live, I'm starting today's live. I already have some live comments. In the same way as the normal format, I will switch between the comments on the channel and live questions. And I will take only the live questions when I am doing that. Please don't type any live questions beforehand. I see that there are some live questions. I'll try and answer them to begin with. So the first question is from Suna. I'm an international student studying MSc. So first 5 minutes for live questions. From Pakistan studying MSc MGT Code of Life. Firstly, I am giving a shout out to Prince Chawla, who has become a bronze member. Thank you for supporting our channel, and it's very helpful. I would encourage anyone else who wants to consider becoming a member. That would help our channel and grow our channel more. So thank you very much, Prince Chawla. Okay, so the first question from Code of Life Suna. I'm an international student from Pakistan. Uh, MSc, okay, with placement 12 months, okay, plus 6 months placement, 12 plus 6. Can I apply PSW after 12 months academic after taking exit from university? Yeah, this question about your course completion, I'm not sure how the university defines your course completion. Is your placement also a part of the whole course, and the university thinks that. So the first question, okay. So if the university thinks that placement is also a part of the course, I don't think you're completing your course without doing the placement. Usually, to the best of my understanding, I'm not experts in courses, but unless you complete that placement, I think your course is not termed as completed. But I think your university is the best source, your admissions office, speak to them. They should be the best people. Immigration rules or UKVI doesn't have much to say over here. If you have completed your course successfully, which qualifies for the graduate route, only then you would qualify for a graduate route visa. So that is my answer to your question. As per the government website, what you say, students can go for PhD if the degree length is more than 12 months and they have completed 12 months. Yeah, that 12 months thing is for PhD degrees, not for normal degrees. I think you are doing MSc. Yeah, specifically regarding the degree definition, whether it falls as a PhD or not, your university is the best source to ask them. I am an immigration lawyer. I cannot advise you on the definitions of a PhD course, etc., whether your MSc qualifies as a PhD or not. So that is my answer. The 12 months of study option is only for PhD occupations if you completed or something like that. So to the best of my understanding. Ajay Reddy. Next, there is a gap between 12 days overstay between the visa application, and how can I rectify the mistake for the future application? Application of 12 days overstay, I want to switch to dependent visa. Usually if you apply after overstaying, so you made an application after overstaying for 12 days, it is not an in-time application, it is called as an out-of-time application, and it is a PBS, either dependent or main, whatever that is. They may not consider your application. That is how immigration rules apply. I'm not sure whether you got a decision or not, but I think they may refuse the application or reject it. They may refuse the application because it is out of time. This standard immigration rules in the UK. If you make an inside UK application, it has to be in time. Unless there are reasons beyond your control, up to 14 days you can apply, but you need to give evidence as to why you could not. It can be medical reason, any other reason, but those are the only exceptions. You will have to give some evidence to show why you could not apply before the expiry of your current permission. That is my answer to the live. I will go to comments and I will answer the comments for the 5 minutes, and then I will come back to live questions. Please don't ask any live questions now. I will start the live again. So yeah, don't type any live questions. I won't be able to answer them. 5 minutes I'll be taking comments on the channel. So let's sort it. I'll just try another method this time. Maybe public subscribers who publicly subscribe, they have this icon, the red button over here. I see publicly subscribe. What is the discount salary for PSW visa holder? PSW visa holder, I think you're talking of the new entrant salary. That's how I understand. If that is not the case, you can write another question or come live and ask your question. It is 80% of the whatever the minimum salaries are. For example, currently it is 80% of 26,200, that is comes to about 20,960. After the salary increase on 4th of April to 38,700, after the normal salaries increase to 38,700, it would be 80% of that, that would be 30,960. So that is the discount for PSW graduate route holders switching to a skilled worker visa under the new entrant category, and can get up to 2 years of the skilled worker visa under that category. Okay, next question. Femi Matthew, my friend lost her job in October 2020. She is yet to get another one. A visa will expire by ending February. So I think it might have already expired. She's a student dependent, spousal dependent, since dependent, but a partner abandoned her since she came to the UK. PSW visa together. So I think the question is about, she's a student dependent. So a student dependent, my friend lost her job. So your friend lost her job. She is yet to get another one. Her visa is student dependent. Partner abandoned her. Yeah, if you are no longer with your partner and you are on a student dependent, and the student, you are no longer living with the main student applicant, then I think you may think of switching to, can you switch? First question from dependent. Yes, inside the UK, if you get your own sponsor and you want to switch to your own skilled worker, healthcare worker, or whatever those visas are, you can switch for any eligible visa. Those are the only options that you may have. So yes, she can apply for a, you're asking no possibility of filing tier 2. You can apply for not the PSW, because you're not the main student and you're not with the student. So the dependent can only switch to a tier 2 skilled worker visa. That would be the only option for her if this question is still valid. I understand her leave is expired by now maybe. Okay, so those two I have answered. I'll take some subscriber count. So whichever questions have anything over 10,000 subscriber count, no. Anything over 1,000 subscriber count. One more minute for live questions. I'll come back to live. So now I'm taking this one. Okay, let's take from the bottom. Subscriber count. Thanks for the informative video. Shalitha, question from Shalitha. Need some clarification. In the screen it shows 38,700. I think I may have answered this one. Yeah, this one is already answered. Okay, so this is not the right way to sort. Okay, I will come back to the main comments. Response status, I haven't responded, apply. I'll try to do a count and answer them with the random numbering. Okay, 5 minutes over. I'll take live questions for the next 5 minutes. If anyone is live, you can ask any questions now. So, okay, I have Akhil's one question. Akhil, hi sir, I'm Akhil. December 5th, my biometrics was done. Student dependents visa with priority service. After that, no. December, no decision. After that, on 28th December, I got mail stated. Yeah, what does your mail state? You may have to maybe write something or copy and paste what your mail states. Yeah, you filed your biometrics, but there is some that mail that you have received. Maybe type whatever you want to ask. Okay, if there are no live questions, I will go back to the comments for now. many do we have? 1, 2, 3, 4, 5. 2, 3, 9, 9 plus 45. I'll use the random number generator as I usually do and select the question 45, 43. So it should be 1, 2, 3. When will I be able to come to England with my partner? Okay, I think you are asking when will nurses be able to come to England with their families? Okay, so this is the question on the care worker visa. The dependents are not allowed on the two job codes 6145 and 6146. Budhika Priya is asking when will nurses be able to come to England with their families? So unless, assuming the current rules continue, unless the rules change, that may be one thing that happens, and then if dependents are allowed at any time, I don't know about that. But the dependents can join under the current scenario after the main applicant. So the main applicant comes to the UK without the dependent, lives in the UK up to 5 years, for at least 5 years, applies for indefinite leave to remain, and then the main applicant can sponsor the dependents, the partner, husband, wife, spouse, or any children under 18 years of age. So the sponsoring would be possible after the person gets indefinite leave to remain. So that is what those are the two questions you have asked. So the dependents can come only after the main applicant gets indefinite leave to remain, the care worker gets indefinite leave to remain. Okay, I'm still in the lifetime, so I will take Obey's question. I came last year to the UK. I'm on a care worker visa. I had, okay, let us live question. I came last year to the UK. I'm on a care worker visa. I had no dependent on my visa. If I marry now outside UK, will I be able to bring my spouse to the UK? Okay, Obey Tariro, the current rules will not affect you. You can, because you came under the old rules before the change happened. You can still bring your partner. You can get married now, and your partner can join you as a dependent. So that is good news for you. So if this question answer does help you, do like the channel, subscribe to our channel, and yeah, like this video. You can, yes, you can bring your partner. Ajay Reddy, you have clarified because of university delay results. I waited more than 12 days, but I am failed project. Failed project. So there are two things on your case, Ajay. So you also failed project. So failing is not an issue. What are you applying for? Switch to a dependent visa. So a student switching to a dependent visa. Yes. So if you were in time before your BRP expired, before your permission to live in the UK expired, dependent visa permission. So you want to switch. So I'm assuming you are a student. You want to switch to becoming a dependent of someone, and your course is completed but you have failed the project. So unsuccessfully completed the course. Completion is fine, doesn't matter whether it is successful or not. So on that basis you can switch to a dependent visa, but the only problem is you have overstayed 12 days. So you may not be able to apply from inside the UK. That is what the immigration rules say, unless you can try and ask for any exceptions from the Home Office on that. But it is at their discretion. I don't think this may be accepted as a reason because of delay of university delay results. You could have filed an application before time, in time also, and then send the results, because the results were not relevant at all. It's course completion, whether successful or not, it doesn't matter. So it may be a problem for you to switch from inside the UK. You may have to go outside the UK and make an entry clearance application as a dependent. So that is my answer, Akhil. So please give me your email ID or source to talk with you. Okay, so the only way, I understand that individuals always try to contact our office also and write emails about the consultation. There is a consultation fees. We have a paid service. We don't provide any free advice outside of this YouTube channel. So you may go on the YouTube channel link. There is a website. You can fill up the contact form or call the office, and they will send you the consultation details, the fees, and the timings, etc. So that is the only way you can speak directly with me. So someone from office will contact and reply to you. So that is what I can say. 1, 2, 3. Okay, all the live questions are answered. Let me go back to the comments. I've already answered 1, 2, 3, 42, 42, generate 36, 7th 1, 2, 3, 4, 5, 6, 6. This one. Question from MMAT884. I'll come back to live questions in 3 minutes. Hello sir, I am from Mauritius. I am 54, have a caregiver certificate from Ireland, and have experience too. Would like to know how to apply for work visa. Sorry, this portal is only on advice on UK visas. I cannot advise on Ireland visas. I don't know the laws of Ireland. I'm only a UK immigration lawyer. Sorry about that. So I cannot answer Ireland visa questions. So if you are, I will anyways answer on the UK perspective. If you are thinking of UK visa, if you did not ask it properly, you have a caregiver certificate from Ireland. Okay, you studied in Ireland, you have the caregiver. Would like to know how to apply for a work visa. The caregiver or care worker work visa, you cannot apply by yourself. You have to apply for a care worker job with an employer in the UK. They give you a certificate of sponsorship, and then you apply for the care worker visa. Those are the steps for applying for a caregiver or care worker visa. So that is my answer to your question. I'll take one more question and then come back to the live. 2 minutes on the questions. Let us see. Random number generator. Number 1. Interesting. Okay. So the question is, thank you very much for this wonderful contents. Gino, thank you for watching the channel. I would like to ask my wife was having BRP. We are under the dependency. For now the visa expired last 18th of Feb. Visa already expired. That is a problem. Then not renewed from the same company. Okay. However, the company have applied for a fee waiver extension. Okay. And we are using it to work until 30th August as per the Home Office. So now my wife obtained a new course as a care worker. Does her dependents will also be having visas as per the new law? She is already on the previous rules. Guidance will be okay. So my wife having BRP, we are under a dependency. Okay, so the question is, wife is the main applicant and there are dependents. Your visas have expired. You all came under the previous rules before the care worker dependents not allowed rules came into play on 11th of March. So you are under the previous rules. You have extended by filing a fee waiver application. Okay, so you are in time. You can withdraw the fee waiver and apply for a new application. Okay, that may be possible. You have applied a fee waiver extension and we are using it to work until 30th August. Yes, you will have section 3C leave. Yeah, that should be fine. If my wife obtained new course. So if your wife obtains a new course as a care worker, does her dependents, I'll come back to live questions after answering this one. Does her dependents will also be having visas as per the new law? Yeah, you all will be in the old rules only. Your wife is, because your wife entered in the under the previous rules and dependents are already there. Now if she gets a new course and switches employer or applies with the same employer, then the dependents can continue living in the UK. The new rules of dependents not allowed does not apply to you guys. Okay, coming back to live questions. Let's go back to live. Okay, several live questions. So Akhil, 4 months over, my dependent visa still not result. December 5th biometrics, can I cancel or wait? Can I go with tourist? My wife is also not talking, taking So I'm assuming you are outside the UK and you applied for a dependent visa on your wife. What is the main applicant's visa? What is your wife's visa category? Is she a student? Is she a care worker? Skilled worker? Yeah, please write that. I will answer accordingly. So 5 minutes for live questions. If me and my okay, I am in UK. Last 1 year took medicine. This is also one reason I could not complete studies in time. Yeah, I think Ajay Reddy, you need to speak to an immigration lawyer. Speak to an immigration lawyer about your case. You have many matters of discretion or human rights. You are talking of your medicine, health conditions, etc., etc. Why you cannot complete your studies? Take proper advice from an immigration lawyer. It will be difficult for me to advise on discretionary basis any conditions that you are telling me. I can only answer on straightforward matters over here, which can be answered within a minute's time. Sorry about that. Akhil, please, okay, that is done. 4 months. Yeah, so Akhil, you applied for a student dependent visa 4 months over. You should, if you applied outside the UK, then call that UKVI customer service. You pay some nominal fees and speak to them, and that is one way it gets escalated to the case working. That's the only way you can escalate from outside the UK, unless you have a lawyer who can directly escalate to the seniors. So that is one option. Or if you're student dependent, maybe through the university, if you can, your the main applicant, whoever is the main applicant, student, your wife, she can speak to the admissions office and see if they have any contacts to home office and they can raise it. Other than that, I cannot advise you much, yeah, because I don't know much of the facts of your case. There are many applications which are even filed by priority, they are getting stuck. This is a problem with the home office at last system. They have two systems. There is a lot of data being moved from one system to another. Even we have had applications for priority applications and they took up to 1 month or so. I've seen that. We escalated it to seniors and then got it sorted. There are a lot of system issues. I think your application may be hit by one of those system issues. There are many system issues going on with home office, BRP, incorrect dates, etc., etc. Applications going in the black hole, even home office not finding it, etc., etc. Priority decisions not flowing through. In our case also, a priority decision was made, approved, but decision was not flowing through. The email was not coming to us. So there are many issues with home office. You may have to raise it. The only way you can raise outside UK is call that customer care number and ask them for a status update. They raise it to the case working, number one. Number two, ask your main applicant student to speak to the admissions office and this issue. They may raise it, or wherever the student is living locally, search for the local MP, member of parliament, and raise it to them. The student can go and raise it to them and tell them that this is the problem and you are waiting on the decision for considerable period of time. So that is the only answer I can give. Okay, I have 2 minutes for live. Hi, if me and okay, Shamik Rakshit. So Shamik is a member, so I have to answer his question as per our terms of YouTube conditions. Members, okay, Shamik, thank you for being a member and asking this question. I will take your question first. If I don't receive a curtailment letter and if I apply for a skilled worker visa after 60 days of my last employment date, will my ILR clock reset? No, your ILR clock will not reset. I understand the question. Yeah. So from the home office perspective for ILR, mainly last date of employment is not a matter at all for them. For them, the only dates they calculate is from the date they issue any curtailments. That is how they will count. Any breaks are only from those dates. Your last date of work is not relevant for any ILR calculations from the home office's perspective. So that is my answer to Rakshit. Okay. So I have 1 more minute. I will take one more question. Thank you, Rakshit. Okay, next question. Kulsum Khan. This is the last live question I'll take. Then 5 minutes I'll go back, and 5 minutes I will come back again. So if me and my partner, assuming to be husband, both are in the UK. So according to the new spouse visa rules, can we show combined income? Combined income. Both are in the UK. Yes, if both of you have a right to work in the UK, you both can combine your income and use for the financial requirement meeting. That is my if I also if I get spouse visa, do I have to show 5 years for ILR, or can I use previous years from my student visa time and complete 10 year, get ILR, 10 year and get ILR? Yeah, so you are talking of two applications over here. If you go on to the spouse visa and then you can continue on the 5-year route to settlement, get the 2.5 year spouse visa. After 2.5 years, extend. After completing 5 years, you can apply for ILR, or you can, if you are already qualifying on the 10-year route to settlement, not the 10-year route to settlement on private life, ignore that. 10-year long residence, which is a combination of any visas other than visitor entries or visitor visas. So if you are a student visa, spouse visa, any other visas, you can also apply on long residence if you do qualify. There is quite a strict requirement of 548 days absences in 10 years, 184 days not outside for more than 184 days. So those are the main absence requirements. You can look at the rules. If you meet, you can apply under the 10-year long residence also. Whichever one is first and you are eligible, you can use either of them. Okay. For the next 5 minutes, I'll go back to the comments and then I will come back to the live questions. Okay, so the comments, random number generator, let's do 14, 5, page down to 10, 11, 12, 13, 14. Okay, so the question from Amar Vahora. I'm in the UK on a healthcare visa. Since from the last 2 years, I want to change sponsor with a different occupation code like restaurant, takeaway. Okay. This case, my 2 years of healthcare visa are countable when I apply for ILR. Yes, the answer to that one is yes, you can count. The health and care visa is also a part of skilled worker visa and other visas, sponsored visas that you will get, whichever other options you're thinking of, that will also be under the skilled worker. So that can be counted towards the ILR. So that is one. My 2 years of healthcare visa are countable. Yes, they are countable towards your 5 years of ILR. So I just need 3 years of sponsorship. Is okay? Yes, it is okay. You only need 3 years of sponsorship. As a couple, I am the main applicant and my husband is on a dependent visa. Okay. If we change the main applicant, so the dependent becomes husband and I become dependent in this case, my last 2 years. Yeah, if you change the main applicant and the dependent, so if the dependent becomes main and the main becomes dependent, then you have to complete new 5 years. You will lose the previous 2 years on the healthcare visa. So remember that if you change the order, so the main applicant becomes dependent, then as a dependent you have to complete new 5 years. As your partner who is becoming the main, he or she has to complete 5 years on his own for the ILR. So if you change the order, the main becomes dependent, dependent becomes main, new 5 years will have to be started. Okay, next question. 3 minutes. I will come back to live questions in 3 minutes. I think I'm already done with them. Just take. Okay. Okay, the question is from Win with English question. Is there a possibility of rejecting visa with this dummy reference condition holding biometrics until you get costs? Yeah, depends. So the question is about filing a skilled worker visa with a dummy cost reference. So we use that for several other reasons. If leaves are expiring, lawyers usually do that. We do that. We have done that successfully in the past. But if you're trying to circumvent the rules, for example, if you're trying to file an application before the rules change, and let's say dependent of a care worker, you file an application on 10th of March just because so that you can attach dependents, it will be at the discretion of Home Office whether that application can be considered as valid and decided on. They can declare it as invalid. That is provided in the immigration rules. So they may or may not consider it. It's a 50-50 chance. That's what I can say. Okay, how many questions now? 1.5 minutes more. I will come back to the live questions. Okay. Let's do 22, 15. 22, 21, 22. Okay, question from Tashna 622. Hello sir, my spouse living in the UK. My spouse living in the UK rent a shared space and the landlord doesn't want to give a tenancy agreement, saying he shouldn't rent the place. Saying he shouldn't rent the place. Okay. My spouse is in the process of applying for the spouse visa. What can he use to prove accommodation? Okay, so you have two options. One is you negotiate with the landlord, and if it is not leading to overcrowding, and if your partner is going to come and live over there, then you can get a letter from the landlord, attach the tenancy, and the landlord status saying that once the spouse of Mr. Miss X gets the visa, they can come and live in this property. I have no objection. That is one option. If the landlord is not agreeing, you may have to look for alternate accommodation. You may have to get a new tenancy agreement from some other landlord, maybe for a room at least, where they are allowing both of you to live. So a new tenancy agreement. It doesn't have to be a proper and a long agreement. You can Google search for even a standard agreements of 1 or 2 pages and sign that across. But make sure it is genuine, because they will ask, they may confirm with the landlord. So yes, that is my answer. You will have to find alternate accommodation, maybe at least rent a room, rent another property, whatever that is, for meeting the accommodation requirement. So that is my answer. I will come back to live questions. 5 minutes. Let's go to live. Okay. Answered. Okay, my partner. Okay, I think I answered. Okay, moments ago. Okay, Akhil. So now you have added further information. Your partner not talking with me. So I don't know whether your relationship is still subsisting or not. You need to sort out your relationship first. If your partner does not support your application, you will not get a dependent visa. So remember that if they call your partner or do any type of investigation with your application, that may be an issue. So I'm not sure what is the issue with your previous application also. Maybe your partner is not supporting it, or what the issue is. So you need to sort out your relationship first and then a visa application. That's my advice. Kiran Reddy, question around dependent visa extension. Okay, dependent visa extension of skilled worker. I'm currently on a dependent visa which will end in Jan 27. My wife is skilled worker visa that will end in March 28. She has 28K. So if you're already on a dependent visa, you can continue to extend. I'm assuming, yeah, so visa extension of skilled worker visa. So you are a dependent and your wife is the main applicant on a skilled worker. You can continue to extend. I don't see any issues since you are already under the old rules. If you are asking for extension of your wife's visa, the main applicant's visa, she earns 28K, it will be after the rules change to 38,700. The current skilled workers can only extend, the minimum salary will be increased to 29,000, or the salary for the occupation code, whichever is higher. That is the formula. So at least she will have to be paid 29,000. So next live question, Mohammed. So I have applied for skilled worker visa on 9th of March. 9th March, today is okay. With my wife being a primary holder with 2 kids, my solicitor said we are going to put one supporting document. Okay, solicitor said we are actually waiting for cost allocation since January. Okay. Yeah, I need more information. I understood the facts. You applied pending costs. That is what many lawyers, many applicants have done. But what is your question, Mohammed? Type that, please. I understood the facts of the case. It is filed pending costs. So the solution would be, I will just discuss briefly on that. Whenever the cost comes, that cost has to be provided to the Home Office. There is a 50-50 chance they may also reject it as invalid. As per the immigration rules, they can reject the application as invalid without a valid cause. But I am not sure. I don't think they are going to do that. It is their discretion. I cannot comment on that. The rules allow them to declare an application invalid if it does not come with a valid cause. So this is what most of the legal representatives, solicitors, lawyers will be trying. Yeah, so once the cost comes, so two options: one, they declare it invalid, or if it is kept on hold, whenever the cost is approved, that has to be provided to the case working team and they will continue processing the application. Okay, Kate Harrison, I have one more minute. I'll take this live question and then go back. I applied for my outside UK skilled worker visa biometrics March 21, February 21. New, for the new rules when I want to renew my visa in 2026. What threshold would I need to meet? 29,000, 38,000. Feb 25. 29,000 will be your threshold. Yeah, because it will go back to 25th percentile, and because you applied under the old rules, 38,700 was not live at that time. So anyone who is extending, who is already in the UK, or the date of application is before 4th of April. 4th of April, the skilled worker salaries will increase to 38,700. Any applications where the date of application is 3rd April or earlier, you will still be under the old rules. So for Kate Harrison, at the point of extension, you will have to be earning at least 29,000 or the occupation code rate, whatever, whichever is higher, if it is higher. So I'll come back to the live questions. 5 minutes, I will answer the comments. Let's on the channel. Let's go back to the channel. Okay. $32. 35, 34, 33, 32. Okay, what is the discount salary for PSW visa holders? I think I've already answered that anyways. Let's take the next one. So you are saying all the new rules are applicable if you are on PSW dependent since last year. Can student, so the question, I'm trying to understand the question, can student dependent switch to care worker, student dependent switch to care worker dependent? And yes, I think so. So you are saying all the new rules are applicable if you are on PSW dependent since last year. Yes, I don't understand the question clearly. What you are stating, Dharmik, is so you are saying all the rules are applicable if you are on PSW dependent since last year. Yeah, so I think what you are trying to ask is there are many questions I have been asked. Can a student dependent or a PSW dependent who is already in the UK, where the main applicant switches and becomes a care worker? So that is what I understand from, I'm trying to interpret it to the best of my understanding. If the main applicant, either the main student or the main PSW graduate route holder, switches to a care worker visa, the dependent cannot continue living in the UK. They will have to leave the UK. So because the rules have changed, those job codes don't allow dependents. So even if the dependent is already sitting in the UK on another route, either a student visa dependent or a graduate route dependent, they cannot continue to live in the UK if the main applicant switches and becomes a care worker, 6145 or 6146 job code. The dependents will have to leave the UK. So that is my answer. If that is not your question, please clarify. Okay, 2.5 more minutes and then I will come back to live questions. Okay, let us do 7, 6. Okay, 1, 2, 3, 4, 5. Question is, okay, very long-winded question. I will try to summarize it. This is the long one. From outside the UK, I submitted my skilled worker visa. Awarded 20 points. What is the question? What qualifies an applicant as granted permission skilled worker under the rules, and does the valid from the date of visa vignette? Okay, what qualifies applicant granted permission skilled worker? Points if the date of application. Okay, I think this question is exactly similar to Kate Harrison's. I think it is a K. Maybe it is the same person asking the question. So yeah, if you have made the application on 5th of February, that is under the old rules. So you will have to earn a salary of 29,000, the 25th percentile, if you file for extension. Does the valid from vignette? So you still come under the old rules. That is my answer for this question. You submitted the application on 5th of February. That's what I care about. I don't care what happened next. The date of application is what matters for application of the rules. Which rules apply is when the date of application is. 5th of February 2024 is the date of application. Skilled worker, even care worker rules are changed on 11th of March. If you are in that, that won't apply, or even the 38,700 rules won't apply to you. So you come under the old rules for both of them. So if at the point of extension you need 29,000 salary. One more last question. I have 45 seconds. Let's take that one. 13, case 7, 8, 9, 10, 11, 12, 13. Okay, here it is. Many thanks for your video. Okay, could you please make a video? Sponsorship requirement, hourly base salary. Okay, yeah, I think I have already that. Yeah, once the rules change, maybe I will consider making some video. At this stage, no, but I think you have asked some question. I will try and answer your question. Where is your question? Yeah, I cannot find it. That's okay. I'll come back to live questions now. Let's go back to live. Okay. Kate Harrison, I replied. Okay, Meet Patel, next question. I applied a student visa in 2021 for PG program in UK. I got my visa application approved, then university withdrawn my sponsorship, so that's why I didn't travel. Am I eligible for a refund? Refund of what? IHS refund if I don't travel. Very interesting. Okay, visa application that is already refused if you don't travel. Logically speaking, yes, you should be eligible, but to the best of my knowledge, I don't think there is anything in practice that Home Office will refund you the IHS fees if you don't travel. To the best of my knowledge, there is no way to get that IHS back, because if your application is refused, you do get your IHS back or you withdraw your application. But if an application is already approved, or what has happened on your application? Where is didn't travel? So you didn't travel. Your visa was approved, but you didn't travel. You will not get a refund of the IHS fees. I don't make the rules. And I know from practice, Home Office will not give an IHS refund if a visa application is already approved. So Sheikh Babji, suspended student due to non-payment fee can again apply for student from home country. Yeah, suspended student. So suspended means the university reported you for non-payment of fees, saying they are no longer sponsoring you as a student. You may be able to. I don't think there is. If you don't have money, you don't have money. It's unless you have broken any other immigration rules, worked more than 20 hours, whatever evidence Home Office has against you, any criminal conviction, anything like that. If everything is clean, just for this reason, unable to pay the course fees, I don't think it's an issue. If you do leave within time, before the end of your leave, permission to stay, or before the end of your cancellation, as end date as per the cancellation email that you receive from Home Office. I don't think that should be an issue. Kate Harrison, thank you very much. Okay. Okay, anyone who is getting any helps, please do like this live. If I do get 100 likes for this live, I have decided to make another live within this week before Tuesday. So every Tuesday I do go live. So within the week I will do one more live if I get 100 likes. If this live is helping individuals only, then it makes sense. Wasting, or if I'm just wasting my time, I need to know that. That's very important. So Muhammad Rahimuddin, my question is that what are the chances of getting approved as a solicitor is awaiting cost allocation? Yeah, so the question about that pending cost application, it's a 50-50 chance of success. One option, Home Office can refuse it, saying invalid application, and reject it back to you. Second option, they can keep it on hold, and then once you provide the cost, they can decide on it. Both the options, 50-50 chance of success. That's my answer to Muhammad Rahimuddin. Thank you, Sheikh Babji. Everyone who's getting any value in this live or in any other videos, do subscribe to our channel, like this live or any other videos. That's my pitch. Okay. Yeah, I understand, Mohammed. You are worried, but those are the only the chances. I can tell you the chances of success from the facts of the case. Yeah. Kalyan Venumula, I applied for Tier 2 skilled worker visa 3 days back. When I can expect visa approval? Tier 2 skilled worker visa, maybe skilled worker visa 3 days back. Depends on what is the. Did you apply inside the UK or outside the UK? That is the first question. If you applied outside and used standard service, 15 working days is the standard service. And if you applied inside the UK, about 6 to 8 weeks is the standard service. That is my answer to Kalyan. Okay, based on the current issues discussing during this live, do you recommend using priority service for those applying outside the UK? I don't think all applications are getting affected, but I have seen many issues with these priority applications. I have got many, like out of every 10 we file, we've got almost all of them, I would say. Only one I saw which was an exception. So I don't think you should decide on this basis. There are system issues even with normal applications, standard applications. It's not the Atlas system is big, it has many issues. So uh, I think you should decide accordingly. So you can apply either priority. My answer is to Kate Harrison. You can apply priority standard. I don't think it matters depending on what are your timelines of traveling to the UK, etc. Still issued. So Hasna, still issued skilled worker costs. Okay, 5 minutes done. I'll go back to the comments answering in 5 minutes. I'll be back to the live questions. So going back to the comments on the channel. Okay. Let's do a random number generator. 19, 14, 15, 16, 17, 18, 19. Okay, this one. Veera Kumar. I'm on a dependent visa and I'm waiting for costs as carer. Dependent visa, waiting for costs as carer. Okay. Now can my wife switch as a dependent as per the new rules? So 3 days ago you put the comment, do I need to apply for my dependents when I change? Okay. So you are on a dependent visa, maybe dependent of anything, and you're waiting for a course as a carer, and my wife switch. So you have not applied for a care worker visa. If you have not applied for it and the rules have already changed, and if you are applying for one of those, you will be applying once you get the course as a carer 6145 6146. You will not be able to sponsor your wife. Your wife cannot stay in the UK as a dependent because those job codes are a problem. Your switching may be allowed, but your wife will not be able to switch to become your dependent. Sorry. Okay, next question. 24. We are on 19, 20, 21, 22. Okay, same question asked 3 times. Can Tier 2 visa holder before March 11th can switch to a dependent visa? The dependent got healthcare skilled worker visa after 11th March. No, that is not possible. So the dependent, so there was a main and a dependent. Main was on a skilled worker visa. The dependent switch to the care worker visa. If the dependent has switched to one of those two job codes, 6145, 6146, then you cannot switch and become a dependent. So my answer is no to that. Can Tier 2 visa holder? So you were already on to a Tier 2 and you want to become a dependent. That is not relevant. What is relevant is the dependent got healthcare visa after 11th of March. If the dependent, when you say got, I think the date of application is what matters. If the dependent has filed the visa application before 10th of March, before 11th of March, say 10th of March or before, then the dependent will also come under the old rules and they can sponsor you. So that is possible. But if the date of application when the visa fees and the IHS fees is paid is 11th of March, then the dependent cannot sponsor you to become the dependent. So the dependent switching to main. I understand the question. Okay, right. So this one is done. It's done. Repeated questions everywhere. Yeah, this is a request, please. Anyone writing questions on the comments, I do get all the comments on the channel. So please write it only once. I see it. This is what you're saying on screen. All the comments are there. So please don't write 1, 2, 3, 4. 4 times you have written the comments. There are many people doing this. I will start hiding users from channel or banning people from channel if it is just an abuse of the system. Just because you get more counts, I will just ban people. I will do that. So going forward, I'm just warning now, but okay, I have 1 more minute of 28 and just try to answer. Let me take one. Okay, coming back to live questions for 5 minutes. Let's do 5 minutes. 5 minutes of live questions. Let's come to live. What is it? Answer. Hasna AGF, still issued skilled worker costs. I don't understand the question. Please clarify. Kalyan Vimula, thank you Kalyan. Do like this video live if you have got your answers. Kiran Reddy, where to find occupation code for SOC 2135, 2139. Where to find occupation code salary for SOC 2139. Let me see. UKVI job codes. I'll share my screen and show you. So the question, the live question that you have asked, who is asking it? Let's see. So your question, Kiran Reddy, where to find the occupation code salary for SOC 2139. So this is how you find an occupation code salary, UKVI job codes. If you go on Google, search for this term, I think I'm showing it on the screen, UKVI job codes. Click on the first one. Maybe you can find Control F 2139. Yeah, I think these are the normal ones. You are talking of some specific. There is a healthcare occupation codes also. You can search for healthcare occupation codes. Care job codes UKVI, healthcare job codes UKVI. That is another one, I think. Where is the job code? 2139. It is not even on this one. ONS tool 2139. I think so. That's what you said. Information technology. So your question is 2139. Information technology, telecommunications. It should be on. Yeah, you should usually find in one of these ones 2139. Let me find it for you, just 1 minute. Going rates. Yeah, you may have to search for going rates for skilled worker job codes. I'm pretty sure you should find it over here. 2139. Yeah, this is the salary for your 2139. Let me type it. So where is your question? So for 2139 there, that is the salary as per the job code 32,100. I have searched it for you. Okay, I'll take some more live questions for 5 minutes. Where to find, in how many working, still issued costs, thank you. Where to find, in how many working hours. Okay, let's close that window. Where is that window? Okay, coming back to live questions. Mohammed, is in how many working days I can get a decision on cost allocation? Cost allocation, usually speak to your solicitor. When is that they have submitted it? Standard processing time is 18 weeks for a cost allocation for an undefined cost. They may be trying for priority services almost every day. I know there is a lot of problems getting priority service. Even we have hard time for getting a priority service. So yeah, speak to your solicitor how long it will take, what is the when they filed it. 18 weeks is the usual processing time for costs under the standard service. Kate Harrison, thank you, I appreciate your channel. Kate Harrison, yeah, thank you very much for your support. Do consider becoming a member. There are membership options to support the channel. And like this video. Thank you very much, Mohammed. Thank you for your time, Mohammed. Do like this video if you got at least some. I understand you are in stress now. You are worried about your concern. But do follow the channel. I'll put any updates that I get. Jitesh, I applied for skilled worker visa without cost, still didn't get my cost. Is it possible to get the visa and can I apply for my dependent also? Yeah, I'm assuming you applied for the skilled worker visa pending cost, exactly similar to Mohammed's case before that I was talking about. It's a 50-50 chance of success. You have to wait for the decision first. Is it possible to get the visa? You cannot get the visa without a cost. The cost, once you get the costs assigned by the employer, you will have to provide it to the case working team. Then they continue processing the application if they have kept it on hold and they have not rejected it as invalid. So 50-50 chance of success. Can you apply for the dependent also? Yes, if they do approve your application and your date of application was before 11th of March and you are on the care worker job codes, then if they approve your application, then the dependent can join. You can apply for the dependent then. Even if you apply for your dependent now, they will keep it on hold. Obviously, yours is not approved, dependents cannot be. So, Kalyan, on my cause it shows that I am not new entrant. I already said that I applied to my visa 3 days back on my cause. Does the new entrant rules affect my visa? I submitted my visa already. On my cause it shows that I am not a new entrant. Yeah, so if the whatever it shows on the cause, that is what they will consider. The employer has to confirm whether you are a new entrant or not. So I don't know what you are trying to ask me. If the cause confirms you are a new entrant, you are a new entrant. If it doesn't, you are not. Very simple. So you already applied. I don't know what you mean. What is that you are trying to ask me? Kalyan Vemula. Okay, Hasna, I applied for skilled worker course. Still, I did get still issues cost, skilled worker course. Applied for, so you applied for a skilled worker course. You cannot apply for a skilled worker course. Are you an employer? Only employers who have a sponsor license and have a level 1 user ID and access to the SMS, they can apply for a skilled worker course, which is certificate of sponsorship. So are you an employer who is trying to apply for a course? If that is the case, speak to an immigration lawyer and get an advice. On the employer side, I'm sorry, I may not be able to answer much questions. You should speak to an immigration lawyer and get the proper advice on it. Rita, can one ask Home Office for a refund or priority fees if they cannot provide a decision in 5 days? Home Office email that application raises exceptional complex issues, hence they need further. Yeah, this is also common things when applications are not straightforward. If they have sent an email saying there are complex issues, I doubt whether they will give you a refund of your priority fees. You can ask for it, you can raise it through your MP, ask them, but it is highly unlikely that they will give you. If they are treating your application as raising exceptionally complex issues, whatever the problem is, I don't know. So I doubt whether they will give you the refund. If it is because of their fault, their system is not working fine, application decision is not coming through for their issues, they don't have staffing, their system is not working okay, then they do give refund. I've got refunds many times even of super priority. But yeah, if this is the case where your application has some whatever challenges, exceptional cases, then they may not, but still you can try it out. Nothing, it doesn't hurt. Meet Patel. If I approve student visa, okay, 5 minutes. I will go back to comments as usual. Let us go back to the comment screen. In 5 minutes, I'll be back to the live questions. So let's close. Random number generator number 22. Okay, this one. User, it says you at the front. Hello sir, I failed my dissertation and got PG diploma. Can I apply for another masters in the UK? For another masters, I am the wrong person to advise. I am an immigration lawyer. I cannot advise you on the progression, etc. You should speak to the university who you are considering your masters with. Give them your results and your current credentials, and then they will assess whatever they want to, progression, etc., whether they are willing to give you admission in their course or not. That is for the university to decide, not me or the home office. Because if the university gives you, then it is for them to record on their sponsor management system as to why they have assessed you as an eligible candidate and you are eligible for the masters. So it is for the unit to decide, not me. I may not be the right person to answer on that. Okay, 35. Okay, next question is from Rash7476. I am also waiting for the course. My agent told me that they will not issue the course until 11th of March due to some system update. After that, they will issue from 11th to 14th for those who applied already. Is it true? Issuing course. I don't have any such update from Home Office that your agent is telling you. I am a member of Immigration Lawyers Association myself. We get direct updates from Home Office. We have meetings with Home Office seniors. Our members also visit the office and see how the process works. I know the end-to-end process, how applications move from Supersteria to Sheffield to Liverpool or whatever that is happening. I know all the steps, step by step. I don't have any such update that your agents are telling you. I'm not sure agents even have any access to any information from Home Office. I don't know anything about that. I don't think it is true. Whatever your agent is telling you, nothing like that has happened between that 11th and 14th of March. Everything was normal. System may be down for a day or something, but I don't think SMS was working. I know I have logged into several employers as sponsor license, sponsor management system. That is not the case. There was nothing like that. No issues with the sponsor management system, or the courses cannot be issued between 11th and 14th that you are asking. Okay. 1.5 more minute. I will answer these questions and then come back to the live 29. 4, 5, 6. Okay, question. Hi sir, I overstayed my student visa for 7 months. I left UK voluntarily. I am in India since 9 months. I got opportunity as a skilled worker. Can I apply for visa? I overstayed 7 months. If you have overstayed more than 90 days at your own expense, you left voluntarily and you overstayed for 7 months, you have to be outside the UK at least for 12 months, and only after that you can apply for any UK visa application. That is my answer. You have to wait 12 months and only after that you can apply that skilled worker application that you are considering. Okay, 1 more minute and then I will come back to the live questions. Next, 27, 28, this one. I have questions around dependent extension, whether dependent visa will end. I think this question was already asked live, Kiran. Yes, I will still see this. I'm currently on dependent visa, which will end in Jan 27. My skilled worker visa. Submit. If I submit a salary threshold of 38K. So the question about Kiran, I think you also asked live, but I will clarify this one. You provided more details. Because you are on a dependent, wife is on the main, and on skilled worker visa since so if you have, I think your wife on the main applicant, I'm not sure, I'm assuming you are on the previous rules before any of the rules changed, 38,700. Yeah, 38,700 is your question is regarding the salary increases to 38,700, I understand. So at a future time, you are already on the skilled worker visa and dependent visa. So whenever you extend, you will be only subject to the 29,000 minimum threshold at the point of extension. So she will not be subject, the main applicant will not be subject to 38,700, but the formula will be 29,000 or the going rate for that occupation code. As I searched, for example, for someone I just searched, the going rate was 32 100. If that is your case, let's take that example. If that is her job code, I think that was the same job code, 6132139. Yeah, so her job code is 2139. Current minimum salary for the occupation code is 32 100. She will have to pay paid at least 32 100, assuming this remains at 32 100 even at the point of extension. So whatever is the job code salary, that will have to be paid, either 29,000 or 32 100, whichever is higher. So 32 100 is higher, and that will have to be paid at the point of extension. Okay, I will come back to live questions. Hit the screen. Okay, 5 minutes. Meet Patel. If I approve student visa and university withdraw message after 2 days without travel, eligible for IHS refund. Yeah, Meet Patel, I think I answered your question. You are not eligible for IHS refund. Jitesh Jha. Thanks, Jitesh. Do subscribe to our channel, like this video. If I do get 100 likes on this live, I will consider doing another live within a week's time before next Tuesday. Okay, Kalyan Vemula, does the new visa rules and new threshold limits, new entrant rules affect my visa decision? If your employer, so if your employer has confirmed that you are not a new entrant, the new entrant rules don't affect you. Simple as that. Now, new threshold limits. If you have already submitted the application, then the 38,700 threshold does not apply to you, because that is going to change on 4th of April. Yeah, so I answered your question. Both the things don't apply to you, new entrant or new salary thresholds. Okay, thank you, Rita. Thank you very much. Anyone who is getting any value, please do give a thumbs up, like this video, any other videos on our channel, subscribe to our channel, consider becoming a member. Also, there are membership options, and you can get your questions answered much more quite quickly. Many times we answer within 1 or 2 hours also. Worst case scenario within 24 hours, either with a shot or a comment. So yes. Hasna, I applied skilled worker course for 10 days. I didn't get my course. Is it delay? Yeah, for the course there are many delays. You are, whichever course you are applying for. So Hasna, you are not an employer, then how are you applying for a course? I'm not sure. Individuals, applicants don't apply for course. The employer applies for certificate of sponsorship through their sponsor management system. That's how it works. So Mohammed Remuddin, what if my decision doesn't come till last week of June, because I hold my dependent visa only till June? Can I put my request to given that I'm to receive additional cost? Yes, if you are, if so, Mohammed's question is, he has already filed an application. His lawyer has filed, pending cost decision has not come. So once you made an application inside the UK and your current leave is going to expire in June, his question is, if a decision does not come by then, whatever, it is not decided, his skilled worker application is still pending, you still have section 3C leave, you can continue living in the UK, and your current rights will continue till a decision is made by Home Office. So you don't have to worry about your permission ending. since you've already filed in time before the expiry of your current permission. Okay, thank you, Kalyan. Thank you. Do subscribe to our channel and like this video. Okay, no more live questions. Let me go back to comments. 5 minutes on comments. Number 3. 1, 2, 3. Question is about I have lost my BRP. Okay, what is the question? How do I apply for graduate visa if I lost my student BRP? Okay, so Sayyid Taki 418, I have lost my BRP, and so this, where is that gone? 1, 2, 3. This is the question. I've lost my BRP and my visa is getting over till May. So my doubt is, okay, so your visa will expire in May, your BRP permission will expire in May, BRP is lost. My doubt is, should I apply for replacement now or wait for May? Replacement now. Directly apply for PSW, as I know I have to give back my BRP, but these situations I should. Yeah, so the question is, it's an interesting question. This happens to many people. They do lose their BRPs. So if directly apply for PSW. So that is the short I have made. How do I apply for graduate route visa if I have lost my student visa BRP card? So it is possible. We have done that in many cases. I have made that video. That short also tells you how to do that, I think. And also there is another video about this, I think so. So your student visa permission is still valid till May. You lost your BRP, and by May you will also apply, before your permission ending, you will apply for PSW graduate route. If you don't have any travel plans, you can just not apply for the BRP. There is nothing, I don't think you can be penalized for not applying for a BRP unless you need that BRP for any reason, maybe for right to rent check, right to work check, or anything. If you need the BRP, then you may have to apply for a replacement BRP before May. But then if you don't need it till May for any reason, right to rent or any other checks, right to open a bank account, traveling inside the UK, etc., then you can stay without the BRP. That is perfectly fine. I don't think there is any reason why you should spend and waste your money on applying for the BRP just for 2 months or so. So you can wait and then apply, as that video explains you. Without a BRP, you can apply for the graduate route visa through that different online application process. So that is my answer. You don't need to apply and save your money on that. Okay, so 2.5 minutes on the comments again. 15, let's take 13-15 minutes more. I will be live for about 10 minutes or so more approximately. So I will take the live questions again. First 2 minutes 30. Stake. Okay. Hello sir, how does the new policy implementation affect approval of costs for caregivers for singles? Approval of costs for caregivers for singles. So if you are a single person, no dependents, the new policy of dependent doesn't apply to you because you don't have a dependent anyways. Affect approval of costs. Approval of costs will be on the genuineness of the case. Genuine employer, genuine work placement, genuine job, genuinely they have found you, everything is genuine, then home office will approve the costs. If there is any problems, selling of costs, buying, selling, agents involved, just trying to facilitate your entry into the UK by applying for this visa, any issues with immigration, it will be refused. That's what my comment is. 1 more minute on. So let's go to number 7. 1, 2, 3, 4, 5, 6, 7. Okay, submit visa. Okay, this one I have answered. If a person is on a tier 2 visa, can he make an account on Amazon and can work on it? Please guide customer business. Tier 2 visa and self-employed. Self-employment is not allowed on being on a tier 2 visa I would advise against this because the only problem is at the point of ILR, if Home Office finds any incomes generated, reported to HMRC, etc., from any source, rather for that matter, if you get any income from Amazon or any online source, you will have to report it to HMRC. Once it is reported to HMRC, it will be reported under your national insurance number. At the point of ILR, if the caseworker does investigate and they see some other incomes, they may question that. They may or may not believe what you are trying to tell them. The only problem is if you are contracted with your employer on the skilled worker for 37.5 hours, the only concern that they have is you may not be working for your employer genuinely. You may be just having that visa and not working, and working on this Amazon or any other business. So in my opinion, you should avoid doing this if possible. That is my advice. Okay, now I'll take the last round of live questions, whatever, if there are any. Okay, thank you very much, everyone. Okay. Okay, again a shout out to the person who joined, Prince Chawla at the top. Welcome to becoming a bronze member. I invite everyone who's watching this video to like this video, subscribe to the channel, comment on it, ask any questions. Every week once I will go live. If this live gets at least 100 likes, then I will do another extra live during the week. So that's the promise. And do consider taking any memberships and supporting the channel. I will keep on making videos and these lives. And thank you very much.